Good day, students. This recording is on whether the South African Natural Person Insolvency System, or more commonly referred to as the Consumer Insolvency System, is in fact, as it stands today, unconstitutional. It is very important that you can consider these matters so that you can contribute to the discussion in South Africa in this regard. This presentation is based on an article that was published in the International Insolvency Review in 2016, and the title was "Is the Equal Treatment of Debtors in Natural Person Insolvency Law Justifiable? A South African Exposition." Please read this text. It's not only on the Constitution, but it also includes a discussion on the Equality Act. However, in this presentation, we will mainly focus on the Constitution today. The presentation will be structured in the following terms. Firstly, there will be an introduction where the natural person insolvency system in South Africa will be introduced and explained in the broader context. You had formal lectures on this already. However, it's important to explain it once again in order for us to continue then with our constitutional discussion. Thereafter, we will focus on the Constitution and specifically the right to equality, where after concluding remarks and the way forward will be discussed. Although we will in more detail have a look at the South African insolvency system in the next slide and the ones that follow upon that, it's important to note from the outset that the broader South African natural person insolvency system is largely creditor orientated and that it excludes many honest but unfortunate debtors from its ambit. All over the globe, insolvency law developed basically as a collective debt enforcement measure. The idea is to establish a concursus creditorum, where after the group of creditors takes preference over individual creditors, in order to ensure fair distribution of the value that's in the estate amongst credit providers. However, due to the rise in credit and more individuals finding themselves in financial difficulty, the focus has of late shifted to a more pro-debtor approach. This pro-debtor approach originated in the USA and is commonly referred to as the Fresh Start Principle or the Fresh Start Movement. The idea behind the Fresh Start Movement, whereas we assist our debtors, is to rehabilitate them, release them from their unmanageable circumstances and their debt slavery, to render them productive participants in the economy once again. Unfortunately, as was stated, South Africa did not change its focus as of yet, although many of our commercial pieces of legislation has transformed. Unfortunately, the Insolvency Act remains stagnant. This slide illustrates the broader South African natural person insolvency system, and more specifically the different debt relief measures or mechanisms that are available to over-indebted or insolvent South Africans. We have three, that is the sequestration procedure. In the Insolvency Act, we deem it the primary debt relief measure, and then we also have the debt review and the administration order procedures. In the next slides, we'll have a look at these in more detail. The first procedure that we will consider is the sequestration procedure in terms of the very old Insolvency Act, as is a 1936 piece of legislation. The essence of this procedure is an asset liquidation. A trustee will be appointed, take hold of the estate, liquidate the estate, pay the costs that's due, and thereafter distribute the proceeds amongst creditors. Thereafter, the debt will be discharged. So the remaining debt, the outstanding debt after distributions were made by the trustee, will be written off at the time when the debtor is rehabilitated. So a discharge of the debt, and therefore we deem this as a debt relief measure. That is not the aim of this procedure, as the Act was written with the idea of advantage for creditors, an orderly distribution of proceeds in the estate. However, a consequence, not the main aim, but a consequence of this procedure is a discharge of debt, and therefore it's a very important debt relief measure in South Africa. However, obviously not all debtors will qualify for the sequestration procedure, and the reason is exactly because it was written for the benefit of creditors. So if an applicant, whether it's a creditor who applies for the sequestration of a debtor, or the debtor applying for his or her own sequestration, can gain access to the system depends on whether the applicant can show or prove that there will be advantage for creditors. That is a monetary advantage. There's other advantages as well, indirect advantages, but basically the major consideration is whether there will be some sort of a dividend paid out, a pecuniary benefit to credit providers. As a rule of thumb, 20 cents in the rand is what our courts look at. So you can see now that if you do not have sufficient assets to show that your creditors will at least receive 20 cents in the rand, then you will not be able to make use of the sequestration procedure as a debt relief measure. The second statutory debt relief procedure in South Africa is the debt review procedure that is commonly referred to by the public as the debt counselling procedure. This procedure we find in Section 86 of the National Credit Act, which is a 2007 piece of legislation. And although initially there was the hope that this procedure will render a solution to the group of debtors that is excluded from utilizing the sequestration procedure, practice has unfortunately showed that that is not the case. And the reason for that is that the debt review procedure is basically a repayment plan where the relief is such that the term in terms of which you need to repay a loan will be extended, and hand in hand with that, obviously, the installments will be reduced. However, no debt will be written off, so you will not receive any discharge, as is the case in the sequestration procedure, not even for interest. And therefore, practice has shown that the debt review procedure only assists the mildly over-indebted consumers. So if you're hopelessly insolvent, you will definitely not qualify for the debt review procedure. Our presiding officers, and that's the Maj courts, these procedures play out in the magistrates courts, they want you to at least show that there's some sort of an economically viable proposal before they will order a debt review. In other words, if you can, for instance, not cover the interest that run on your debt, on your loans on a monthly basis, debt review will most certainly not be for you. Furthermore, the fact that it's a repayment plan in essence obviously excludes many debtors from utilizing this procedure. So, if we have a look at the sequestration procedure and the debt review procedure, it is obvious that if you do not have sufficient assets to qualify for the sequestration procedure and you do not have sufficient income or any income to qualify for the debt review procedure, you're basically left without any remedy in the South African law. Although there is another procedure, the administration order procedure, you'll see in a moment why that would not necessarily pose a solution. The third statutory debt relief procedure is the administration order procedure that we find in the magistrates court. Although the procedure itself states that it's hybrid in the sense that it's a repayment plan, as is the case with debt review, but it also makes provision for the realization of assets, as the case in sequestration, the latter is rarely employed in practice. Therefore, it basically is a repayment plan, as is the case in the debt review procedure. So the relief is in the consequence of the procedure, in that the term that you need to pay back your loans are extended and the installments are reduced. There is also no discharge, as is the case in the debt review procedure. So it's basically the same idea behind these two procedures. However, Whereas the debt review procedure does not have a ceiling on the maximum debt that can be can form part of the repayment plan. In terms of the administration or the procedure, there is a maximum of 50,000 Rand. So if you have debt amounting to more than 50,000 Rand, you will not be able to qualify for the administration order. A further impediment or a obstacle in accessing the administration order procedure is that obviously you have to have some sort of income, as is the case in debt review. So if you do not have income, you are not able to qualify for the administration order procedure. From the discussion of the different statutory debt relief or insolvency procedures in South Africa, it is clear that the cumulative effect of their entry requirements excludes many insolvents or natural person debtors from any form of recourse, any form of statutory debt relief. And this exclusion is on the basis of those debtors' financial situations or circumstances. This is as if you're able to prove an advantage for creditors, if you have sufficient disposable assets, then you will be able to enter the sequestration procedure with its jackpot, namely the discharge feature. And if you have sufficient income to show that you can pay your debt over a longer period, then you will be able to qualify for either the debt review procedure or the administration order procedure. However, if you do not have assets or income or sufficient assets or income, you will not be able to qualify for any of these procedures. These excluded group of debtors will probably be bound to their desperate financial positions indefinitely. It has also been coined as debt slavery, and therefore Rochelle, in a THRHR article, stated that in South Africa you can be too broke to go bankrupt. From the above discussion, the question arises as to whether the exclusion of a group of debtors based on their financial circumstances is justifiable in terms of the Constitution. In fact, referring to the sequestration procedure specifically, and in more detail the advantage for creditors requirement, Evans first mentioned the possible unconstitutionality of the differentiation that it brings about. That was in 2007 in the International Insolvency Review article. And obviously this article was published before the debt review procedure became effective in South Africa in 2007. I'm therefore of the opinion that Evans's question is even more pertinent within the broader context, including also the alternative debt relief mechanisms, namely debt review and the administration order. Nevertheless, an actual constitutional analysis has not been carried out previously. The aim of this research was therefore to actually do the constitutional analysis and to measure the broader South African natural person insolvency system, thereby including sequestration, debt review and administration, against the right to equality in terms of both the South African Constitution and the Promotion of Equality and Prevention of Unfair Discrimination Act. However, as was previously stated, today we will only have a look at the constitutionality and not refer to the latter act. The discussion that follows is in the context of the right to equality, as is found in the 1996 Constitution in the Bill of Rights, and more specifically Section 9. As you know, as third-year students, the equality principle is one of three democratic values that takes center stage. You can now take some time to read through Section 9 of the Constitution and to pay meticulous attention to the right of equality. I want to draw your attention to specific aspects, and that is subsection 3, which states that the state may not unfairly discriminate, and then further on grounds including, so it's not an exhaustive list, but including the following: race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, and birth. Perhaps in the context of insolvency law, the ground that's most closely aligned to financial circumstances of excluded debtors is that of social origin. And then lastly, 5, I want to refer you to that as well. We'll discuss that in more detail. But discrimination on one or more of the grounds listed in 3 is unfair unless it is established that the discrimination is indeed fair. So if we can show that something is discrimination on one of the listed grounds, then it makes the analysis much easier. But if we cannot show that indeed it is on one of the grounds, for instance social origin, then we need to take our discussion or our argument to the next level. The concept of equality is a very difficult concept to wrap your head around in all circumstances, and it's also a deeply controversial social ideal. In its most basic or abstract form, it intends to show that those who are similarly situated should be similarly treated. Curry and Duvall state that it's not the idea that is so difficult, the idea of equality, but more what is relevant in determining the similarities between people in a specific context, and then what constitutes equal treatment between different people. As regards natural person insolvency, I'm of the view that the similarity between insolvent persons, whether they are from the higher or the lower or the middle tiers of the economy, the similarity is their inability to service debt and the consequential social economic adversaries that attach thereto. What is however dissimilar to their situation is their level of contribution in terms of what they can offer creditors, what contribution they can make towards servicing their debt or part of their debt. As you are well aware of, in South Africa, class is becoming an ever-increasing indicator of inequality, and therefore the South African economy is regularly described as being dual in nature. That's no different in insolvency law, as was illustrated in previous discussions today. That is because people forming part of the higher tiers of the economy and also from some of the middle tiers of the economy do have some form of recourse available in the form of the sequestration procedure or one of the alternatives, debt review measure or the administration order procedure. However, those forming part of the lower tier of the economy, namely NINA debtors or no income, no asset debtors, do not have any form of recourse, as they do not have assets or income that they can offer their creditors. Therefore, the right to equality is a powerful commitment to the transformation of our society, and particularly to achieve substantive equality as opposed to mere formal equality. For that, please refer to Section 9(2) of the Constitution. Substantive equality means real equality, equality in social and economic life, and therefore equality should be considered as a possible avenue towards reaching a solution to NINA debtors' plight. We need to apply the right to equality also to our insolvency law. In applying the equality principle to the South African natural person insolvency system, there's basically, in my mind, 2 overarching questions that we need to answer. The first is whether debtors that face the same financial predicament, although not the same level of repayment capacity, must be treated equally. And secondly, if we decide that they must be treated equally, what constitutes equal treatment within the context of insolvency law, because obviously the circumstances will differ.